So it is. So for the past, 5 years, more than 5 years, this was in a debate, like whether we need a data protection act, whether we need a privacy act. Okay, what are the kinds of terms and conditions, how it should be aligned, whether it should be aligned with respect to the general data privacy acts, which is present in other countries, in a similar way. So those are debates were there around the globe, around the parliament, around the member committee here, and finally they are given a draft version. The draft version has been passed as a bill in both both the houses, and now finally we are there, and this law will be implemented soon. Okay, so before going into the data protection, data privacy, I would just want to ask whether data protection and privacy both are same. I want this session to be interactive, so you can ask questions, and you can stop me anytime if you have any queries, etc. So I just want to start with this word, whether data protection and privacy both are same or it's different. Anyone from the forum can answer this if you have some
They are
visibility.
different.
Okay, in which way they are different?
So data privacy means who has access to data, uh, who has or who can see
E-
the data, and who has authorized permission to see the data and all. Well, data
Excellent.
protection means the tools or the technical safeguarding or the tools and policies to actually restrict or access the data.
Excellent, Gopi. Thank you. You have kind of, given the exact answer. See, although this data protection and privacy are, kind of very important, often comes together. They are intertwined terms wherein, they don't represent the same meaning, basically. See, data protection is focused on defining who has the access towards the data, wherein the data protection focus on applying the restrictions using the modern technology and tools. It is like, husband and wife. Without, one another, other people will not be able to survive. If husband is trying to kind of get escape from home, wife will kind of ask him, where are you going, and how can you go. There are a lot of work inside, so stop meeting your friends. These sort of thing happens in a family, right? Something like that. So data privacy is something, it can't be implemented without applying a proper data protection over it. Okay, so data privacy and protection go in one another, like intertwined terms, which is going in a joint fashion. Okay, so the agenda for today's presentation will be like, first we'll talk about the legislation. See, this presentation, this overview of Data Protection Act in India is entirely on the legal basis, nothing in terms of technical. Okay, completely, what made this, government to think about this particular act. Okay, what is the legislation? What would be the enforcement timeline? Okay, and what are the key provisions of this particular, Data Protection Act, and who all will be the stakeholders here, and what are the penalties if you are if the companies or individuals are non compliant non compliant to this particular bill, and how organizations can prepare for the compliance. Okay, and in addition, as an add-on, we'll be giving an overview of GDPR and how it is different from data privacy and data protection bill, and how we have to prepare ourselves in coming months, like in a quarter or two, how the companies can prepare, how the individuals who are in this line can prepare themselves, and how they can contribute towards the data privacy compliance. We are going to touch base all these terms. So first, let us focus on the data privacy. We'll be kind of focusing on the judicial impact on this. So there are a lot, already Gopa has told what is meant by privacy, right? So there are many different types of privacy that was developed during the time phrase. Okay, like privacy over one's physical space, one's bodily identity, and the information over that identity, and the personal preferences. These are kind of examples of privacy, and this right is very important to safeguard in the digital age where we live today. So because now there are loads and loads of technology around us, loads and loads of information around us. So there is no kind of we don't know whether privacy is really existing. If privacy is existing, how I should be careful enough to protect that privacy through available protection means. That's how we have to think. So in judicial world, what made this, what are the acts which can help in having this privacy as an individual term? The acts like Indian Evidence Act, Information Technology Act, okay, IPC, Indian Penal Code, criminal law, Indian Telegraph Law, Indian Easement Act, and Family Law. All these, legislations, okay, had the provisions that pertains to the term called privacy. Okay, so Article 21 of our Indian Constitution generally, talks about the right to life and personal liberty, but privacy is inbuilt in that. The right to privacy as a fundamental right has been covered within the ambit of this, right to life and personal liberty, and it has been kind of established in a case law, like through the case law known as Menaka Gandhi versus Union of India. Okay, and in similar way, Article 17 of ICCPR, International Covenant on Civil and Political Rights, talks about the privacy, and Article 12 of UDHR, that is Universal Declaration of Human Rights by the United Nations body, that also talks about privacy. So privacy is a kind of a very, very important term, and protection over that privacy is the root cause for building this proper bill, and having a legislation over this bill to make sure that our Indian system also has a proper law towards the protection of the privacy information and data for the people, Indian citizens. Okay. So there are a lot of case laws like Rajagopal versus State of Tamil Nadu, PUCL versus Union of India, Ramjat Malani versus Union of India, Maharashtra versus Bharat Shantilal Shah, Govind versus State of Madhya Pradesh, Justice K.S. Puttaswamy versus Union of India. This Justice K. Puttaswamy versus Union of India is the major case which kind of given a spark over the judicial system, towards the judicial system, to think about that we should have some sort of privacy, okay, for the Indian system, and the protection law should be there to make sure that our Indian citizens information is being protected and it is not mishandled by organizations or other individuals. Okay, so before coming into this privacy, okay, before coming into this particular privacy law which has been passed as a bill, what were the earlier provisions we had in India regarding the privacy? Any idea, people? Was there any, do you think was there any earlier protection with respect to the data or privacy to our Indian people by the government through some, provisions? Any idea whether any provisions were existing for this bill passed?
Not that we are aware of, as well. No.
So am I going too fast for
Other
you?
a small question, Anand, when you
Yeah,
said Menaka Gandhi versus,
yeah.
was that a case that was, was that was there prior to 2000?
Sorry?
You mentioned a lot of examples on X versus Union of India, etc.
Yeah, yeah, yeah.
So there was also a case versus of Menaka Gandhi
It
versus
was
another party.
1978. It was 1978.
Okay, so are you referring to an act at that point of time?
No, not act at that point in time. What I'm saying is whether we had any kind of protection means by the government, which was given to the citizen of Indians. People of India, to ensure that we also had some laws in general to protect the data and privacy. I'm just asking whether you guys are aware of such information.
Not exactly.
Okay, okay. There was something called as IT Amendment Act of 2008, and you guys are aware of that IT Amendment Act, IT
Heard
IT Act.
about this IT Act. Already gone through the IT Act, but not memorized any most
No
of the parts
problem,
there.
no problem. See, these acts were there, like IT Amendment Act of 2018, IT Sensitive Personal Data or Information Rules of 2011. Okay, to ensure that for
Is it
online.
2011 or is it 2018?
No, rules of 2011, Sensitive Personal Data and Information Rules 2011. Okay, these were the significant law which helped to avoid the cybercrime and online trade. See, during the online trade, there are a lot of cyber crimes that is happening. So in order to avoid that, now these laws were passed, and these laws were kind of basic for this Data Protection Act. For example, in Information Technology Bill 2006, what happened was, as per Section 2072, the punishment for disclosure of information, for lawful contract or anything which you disclose without getting the permission from the particular individual, the punishment was imprisonment of 3 years or the fine of 5 lakh rupees, either one of them. But not much people were aware of it, and even if we are aware of it, we didn't kind of go to court to fight for this particular right. Earlier, what I'm trying to say is we had the law, but it was not that strict, and people are also not that much aware that their information can be protected, even if there is some kind of disclosure that happens without their knowledge or without their permission. They can go and fight in the court. The judicial system was there to protect them, but unfortunately people are not aware of that. And even if some people are aware of that, they didn't go to court to kind of fight and get the positive response on this particular cases. So this time, okay, what happened was in 2007, okay, there was a triggering point. Okay, 5 judges, as a bench of Supreme Court, made the announcement that they want to kind of have a 9-judge panel to first access what is right to privacy in India, whether this right to privacy can be included as a separate fundamental right in our constitution. This happened because of one particular card known as Aadhaar card. There are a lot of Aadhaar card information that was publicly available. There are a lot of other cards which was kind of thrown in the dustbin, and it was like there was no value for the data. Aadhaar card is a very, very important data. It gives you the entire information about who you are, okay, from where you are, and what is your background. From that, we can take up multiple information because it has been linked to all our bank accounts, etc., etc. So wrong usage of that particular Aadhaar card, or if it goes to the criminal's hands, from your bank records, from your transactions, from your IT payment, anything can be taken out. So there are loads and loads of information that can be fetched through your Aadhaar card itself. Aadhaar card is that much valuable. Since there was no protection towards that Aadhaar card data, okay, in 2017, that 5-judge bench panel, okay, they instructed the government to construct a 9-judge panel to access what is the right to privacy, okay, whether it can be brought in as a fundamental right. Earlier, as I told you, Article 21 of our Indian Constitution itself gives us the right to privacy as a fundamental right, which is covered within the ambit of right of life and personal liberty. Article 21 talks about right of life and personal liberty, which has been covered in Menaka Gandhi's case, which got filed in 1978. Okay, so when this 9-judge panel was, commenced for accessing the right to privacy to decide on whether fundamental right and right to privacy falls in the fundamental right. Okay, what happened was the 9-judge panel constituted to analyze that this right to privacy qualifies as a basic freedom to the Indian citizens. So there are a lot of legislative initiatives that has been taken to pass the personal data protection law by the Supreme Court, and it instructed the government to see whether we can kind of initiate this particular law. I mean, we can kind of take this particular bill, build up lot of loads and loads of information towards the bill, and how it can be brought in as a law in India. So in 2017, Supreme Court affirmed that privacy as a fundamental right. So based on that, a bench was formed, a panel committee was formed, and a data protection bill was drafted in 2017 to 2018 period. And in 2019 period, what happened was this personal data protection bill was passed in the parliament for the first time. Okay, and the parliament committee reported on that bill with certain amendments. They told that this there are certain changes required, there are certain additions has to be made with respect to the law over the globe. So what happened was in 2022, this PDPB, the personal data protection bill, was withdrawn, and they re-released the bill in 2023 in the cabinet. And that bill had loads and loads of changes. Okay, giving up-to-date information or updated information with respect to how data protection can be enforced in companies in India. And after multiple discussions and after multiple up and downs, and going towards the committee, and getting the review from public and experts in the field, it was finally passed in August in our parliament as a bill. and now the new law will be enforced anytime soon. So just before that, uh, we talked about data protection and data privacy. So are you aware of any of the similar laws in other countries? Anyone?
GDPR.
Okay.
California
But
Data Protection Act.
sorry, Siva.
California Data Protection Act.
Excellent, excellent.
PDPA,
Okay.
Singapore.
Sorry, Vivek.
PDPA.
Okay, okay. You're talking about the Middle East one?
No, Singapore.
Singapore. Okay, okay, okay. So as you know, these folks, our participants said, there were a lot of data privacy regulations in other jurisdictions as well, like GDPR in European Union and Data Protection Act 2018 in UK. Since UK came out of the European Union, there was a Data Protection Act which was drafted in 2018 and passed in UK Parliament, which regulates how to use one personal information. Okay, and it gives instruction on how organization and the government can use that information. So this Data Protection Act 2018 is an extension of the GDPR, which is followed in all member countries of the European Union. But one surprising thing is, as someone said, California Data Protection Act, US doesn't have, one single data protection act. It has a lot of states, and the California Data Protection Act is, which covers one of the states. So there is no data protection law, centralized data protection law in the center, which deals with data privacy and breach. Okay, unlike the GDPR, which covers the entire European Union, and DPDP, which covers entire India. Instead, what they have is in US, similar to a Companies Act 2013, there is a Federal Trade Commission Act in the United States. So this Federal Trade Commission Act has the immense power over the private enterprises to avoid the discriminatory or deceiving market practices. And these FTC informs how this data can be used in the privacy, okay, for the company's website, how it uses power to impose rules, implement the privacy rules, etc. So this Federal Trade Commission acts as an individual body which kinds of commands or provides the information using its power to the companies over there. Okay. So till now, any questions, people, with respect to the general legal information on data privacy in India, in UK, in US?
Another one, the Subbu here.
Yeah, yeah,
Just
Subbu.
to add. See,
Yeah, yeah,
though GDPR and CCPA became a law in 2018, though
yeah,
CCPA has precedence over GDPR
yeah,
being enacted as a law in February 2018 and GDPR somewhere in June, July. Surprisingly, GDPR does not recognize US as a
yeah,
third country for which you can transfer the data without any hassles. Okay, in fact, if you look at the list of the countries that have been approved by the European Union, okay, US is not a part of that list. And surprisingly, Argentina and all these other countries are. Uruguay, Uganda is anywhere there. But again, this US is actually not there as a part of it. So California CCPA is going to be for that particular state, not for the other 50 states in US. And surprisingly, in spite of being or being set as an foremost advanced nations in security and the privacy technology, etc., US is not recognized as a country with the best of the privacy laws by the Europeans. Actually, I just thought let me add a word here from the GDPR perspective. Okay, thank you very much. Thanks.
Thanks, Subbu. Thank you for the information. So, yes, you're correct, Subbu. US is not being recognized as one of the best, privacy law practicer, not just from Europe, the entire world, except US thinks in the same line. So US guys might think that they are super in everything, but when it comes to data privacy, I think GDPR comes as number one, if I'm not wrong.
Does this have implications? If not US, if some other country is rated on par with the US with respect to data privacy, is there implications on trade and such similar stuff?
Subbu, do you want to answer this question? Abhilash is,
Yeah,
I
see,
think it's Abhilash.
Abhi, okay, thank you. Okay. See, because when I saw a ban, okay, I thought something, okay. I mean, okay, see, finally, the data transfer with respect to the GDPR, there is actually a concrete guideline to whom you can actually transfer without a hassle and with some permission. For example, even if when I say the data transfer between the US and Europe cannot be done, but doesn't mean that data transfer doesn't happen. But if the organization in Europe which wants to transfer the data with any of the organizations in US, if they can ascertain certain security controls in place in the US organization, and then they can actually do it. So apart from the privacy, from the security perspective, there is something called as a right to audit and right to penetration testing. So before the European organization transfers to the organization in US, they can ask for certain controls and look out for the attestation report. Okay, let's say the SOC 2 attestation is very popular in US. They can look out for the SOC 2 attestation report because it's much more stringent than the ISO 27001. And if you're okay and with certain legalities and the contract signed with all these NDAs, etc., you can transfer the data. But again, if there is a data breach, irrespective of whether the US organization is going to be a processor or even if it's going to be the data owner, okay, which is the European organization, the penalty is going to be for the European organization because the data owner is always the European organization, not the US organization. So they have to report to the supervisory authority in the respective country and fight the legal battle.
Advan and Subra, this is Abhishek here. I am a
Yeah.
legal professional, so I can add on to it. So question from Aban with respect to data transfer from EU to US, right? So there is a standard mechanism out there. There are standard contractual clauses that any organization will have to enter into. They are binding corporate rules. There is a list of countries that are adequacy decisions. So such mechanism will have to be in place if data needs to be transferred. And there are standard contractual clauses do have these mechanisms with respect to technical and organizational measures every organization will have to take care of, like Subra mentioned. So there is a well-established mechanism for that. Yeah, that's it.
Yeah,
Thank you.
yeah. Thank you for that addition. Yeah, as you said, in contracts where whenever we are kind of executing it, we should ensure that there's a proper clause coverage. I mean, there is a proper coverage with respect to data transfer. That language should be added in all our contracts. Thanks for that information. Abhi, did we answer your question, Abhi?
Yes, both thanks to Adhavan, Subbu, as well as Abhishek. Thanks a lot
Yeah.
for that.
Yeah, thanks. So we kind of covered the basic legislation. What is what about the judicial perspective of this Data Protection Act is all about, and what this GDPR talks in general. What is this US Privacy Act talks, and how it is going to be different from Indian privacy law. Which one is sufficient? We just gave a touch point on that. Next one is the enforcement timeline as per our agenda.
Just a sec. Before moving further, I just
Yeah.
want to ask, when we are talking about IT Act 2000, IT Act 2008, IT Act 2011 with all amendments, when we are talking about IT Act, which general, because not being a legal expert, just asking about IT Act, which act is the latest act we can quote?
IT Act 2020.
IT Act 2020 with all amendments, right?
Yes, exactly.
Okay. With all amendments is the mandatory one, right? On when we are quoting any statement on the legal perspective.
Yeah, Indian Institutes of Information Technology Act laws, which is amended act in 2020.
Okay. Thank you.
Yeah, thanks. So, as I know we touched base on the legislation. In 2023, there is a data protection regime in India which has been implemented. I mean, the law has been passed. So this is a journey of the data protection law in India. In 2017, the Supreme Court has given the affirmation on privacy as a fundamental right, and it formed a commission. And in 2017-18 period, they have drafted a data protection bill. And in 2019, they introduced it as a personal data protection bill, PDPB. And in 2021, the Parliament Committee gave a report on this PDPB. What are the pros and cons? How it can be kind of amended? How a good system can be facilitated through this? What is the process? Okay, what is the timeline involved? How organization has to take measures? Okay, what are the penalties for non-compliances, etc. Okay, and based on that, in 2023, everything got approved in the parliament. In both the houses, it got passed and it got approved. Okay, and in September or October, September we already passed. In October or December, November, we can expect more clear information about the bill. Okay, what the bill has been, how the instructions has been passed in the bill to take it forward. That we can expect anytime soon. That is the enforcement timeline which I'm talking about. The government has announced that it would implement the act within 10 months at max, okay, but they haven't given any effective date so far. Subbu, am I right? They haven't given any effective date, right?
Yeah, sorry. At the moment, yes, but with listening to the news that is actually going around, it should not be more than a year for everybody to comply.
But there is a
Yeah.
news yesterday. There is news day before yesterday. They are forming the data protection board within a month.
Okay.
Correct. Yeah.
Yeah.
So data protection board is like a supervisory authority for GDPR.
Yes.
But
So
the
this
timeline.
IT Act, so the IT Act DPDP 2023 is another addition to IT Act 2020, right?
No. This DPDP is a separate law, okay, that comes in for data protection. IT Act is something different. You see what I brought in IT Act just for giving the information or giving the overview of what were the earlier acts for protecting the cyber crime and other crimes with respect to the information technology stream. So this data protection is on top of it. It's kind of superior to all the acts, wherein it gives you legal protection of how the data protection can be done in an organization. Who are all there to be there? If at all there is a non-compliance, whom to report? If somebody is getting information from you, whether they got your consent, in which form they have to get the consent, who is going to be the data controller? So the data is money. So
So
it involves
this means it's another act parallel to IT Act 2020, right?
Yes, sir. And it is much more effective than all of them.
So, but a DPDP 2023 is talking about only the privacy part, right?
Yes.
And the
Only about
IT Act 2020 is talking about as a whole of IT. It is including the privacy, but it is
specific to ITs, information
it
technology.
is consisting of other aspects too.
Yes, exactly.
Okay.
You're right, sir. So any other questions on this?
So just to understand
just
what
to
are
add,
the sorry.
Just to add, IT Act is just old lady in our house. We cannot ignore that. We have to follow that also.
So that means IT Act at its place. It is with all this law and sections and all. Addition to that, particularly for the privacy part, we have another law that is DPDP 2023, right?
Exactly, sir. And it talks kind of in a more established manner, how this enforcement can be done. Okay, if somebody is kind of trying, this is kind of IT Act and this data privacy can be combined and it can be fought in the court, sir. If at all you're a victim of some, information theft from you, okay, which is kind of a privacy information, which in turns out to be a privacy information, you can kind of go to the specific boards, which I'm going to talk in further slides. You can fight for your right, and you can get that how to say justice followed by monetary compensation, etc.
Okay, so in case of any case pertaining to this privacy as well as some IT Act, because before breaching the privacy, there may be any encroachment into privacy or breaching of any information, unlawful access to any contract and anything that may land into two different
Yes.
sections can be applied. 2020
Yes, you're correct.
and
Yes.
the
DPDP as
second
well.
act is from the DPDP 2023.
Exactly, sir. You're correct. It's kind of a more protective, measure.
Okay, it is another layer of security for the privacy.
I
Yes,
think
sir.
we can focus. I think we can focus on DPDP Act. Then maybe if the time permits, we can talk about other act.
Yep.
Thank you.
Thanks. Okay. So enforcement timeline, as we said, it might, brought into effect in various stages. Okay. And what are the key provisions? What is the scope and structure of this particular, DPDP? See, this act defines the personal data as an information that can directly or indirectly identify an individual. So this personal data is linked to the identification of the individual, and this particular act encompasses the processing of personal data within India in digital format. So how do you want to process the personal data within the Indian soil in a digital format? That particular measures and procedures has been encompassed in this scope and structure of this particular act. And also this act applies to processing of the digital personal data beyond India if it pertains to offering goods and services to data principals within the country. So it generally means that it also gives them steps of how to process the digital personal data outside India. Okay, if if you are giving any services or goods for the data principles within the country, so within the country, okay, you have certain information and you're going to process that information outside. You are going to take that information outside India for giving the services or goods, something like an IT service. If you're trying to get an IT service, if you're trying to take the information outside India, how you can take it up? Okay, that information has also been given in this particular act. How do you want to process that information? So through some contractual means, as Abhishek said here, how we want to include that in our contract, something like that. Here the provision has been given how it can be taken further outside India in a safe way, and how you can delete it after the purpose has been resolved, something like that. Okay, and this act contains 9 chapters, which has 44 sections, and one detailed schedule which gives information about penalties for non-compliance. So, if there is a non-compliance of this act by any organization, there are loads and loads of penalties included. Okay, for what non-compliance, how much is the penalty, etc. There is a detailed section which has been given in a schedule.
Advan, I just want to, before we proceed further, scope
Yeah.
and structure is something which is very important for us to understand in the beginning,
Yeah.
because when you look at GDPR, because this is what most of us have been looking up, how different is GDPR at this particular stage from the DPDP? Because if we don't get this right, probably the next few slides will become.
Okay, then no problem. I'll kind of walk you through that. I have a slides for that. 1 second. I'm just taking you to that slide. I kind of gave that information here. Key difference between the on with respect to scope and structure. What is the difference between GDPR and DPDP? You want me to cover this first? No problem.
Yeah, I think that will be great.
Okay, no problem. So your good name?
Cherish.
Yes. Okay. Thank you. See, this is the key difference with respect to the scope and coverage of GDPR and DPDP Act. So by having this as a base, we can kind of further go further down on that implementation of DPDP and who will be the data process, okay, data fiduciary, etc., etc. So see, when we talked about GDPR, right? The entire European Union, GDPR covers the entire European Union. So GDPR applies to processing of personal data wholly or partly by automated means and to personal data which form or will form a part of a filing system. Okay. Wherein the DPDP will apply only for the digitized personal data and non-digitized personal data which is subsequently digitized. So the GDPR has the process of application of processing the personal data wholly or in some parts by automation through the automated means, and to the personal data it can be in a raw form or in any format, okay, in the filing system. But the DPDP is very much focused and it is very much narrowed down. It applies only to the digitized personal data and non-digitized personal data which is subsequently digitized. So it applies to the structured format of the information, and that structured format will be kind of given by the organizations. So the organization has to give a proper format to you to the data data principle, which kind of going to give the consent about the data. So we'll talk about that more in the slides. And penalties in the GDPR goes to the max of 20 million euros or 4% of the company's worldwide annual revenue from the preceding financial year, whichever is higher. But in DPDP, the penalty at the max is going to be 250 crores for an organization. And how they are going to arrive as a 250 crore, it depends on what is the kind of non-compliance that you have committed, okay, and what is the impact of the non-compliance that has been given over to the data principals. So it all depends on those factors, and the penalty is being decided in this DPDP. And in GDPR, when it comes to minors under age 16, they need a parent consent. And some of the members of the Europe has lowered this age to 13. Okay, I don't remember the country's name. Few countries has given that 13 is the minimum age for parent consent, and in India it is 18. With the consent of parents and guardian, the DPDP information can be obtained from the children with the consent of parents and guardians. And in GDPR, the breach should be notified within 72 hours to the supervising authority. Okay, and who are the affected possible data subjects, we have to notify to them also within 72 hours with respect to the data breach. And this DPDP, the act hasn't specifically given any time frame for the personal data breach notification. We are expecting that in a detailed manner in the further releases of the information given by the government. And GDPR does not include right to nominate, but however they kind of give the information or give the way for right to portability. Organization have 30 days to respond to the data subject request, how you can kind of port the data to anywhere where you want. Okay, but here in DPDP, it comprises the additional right to nominate, wherein it doesn't talk much about right to portability of data with respect to the data principal request. So we can do the data port in GDPR, wherein DPDP doesn't talk much about the data portability.
Okay, great. Okay,
Yeah.
we still
Yeah, we
okay.
still
Please,
have.
okay.
Is it okay if I cover this? And we'll
Yeah, sure.
yeah. And GDPR lays down specific mechanisms for transferring data to the third country through the standard contractual clauses and binding corporate laws. As Abhishek was telling that we should be including that in our contracts. GDPR gives you the specific mechanism for how you transfer the data to the other countries apart from the European Union, wherein our DPDP doesn't specify anything on the transfer of personal data, and it hasn't given any information on the transfer mechanism as well till now. Okay, and here both the data controllers and data processor are under the obligation to appoint a DPO in a specific circumstances. DPO is data privacy officer. Okay, we'll talk about that also. And we'll talk about who the data controller are, who the data processor are, etc. And in DPDP, only the significant data fiduciary shall have the rights to appoint the DPO as a point of contact to the data protection board. It simply means that there is a data protection officer, okay, being appointed in a company. For any breach, he will kind of give the information, he'll be the point of contact within the organization to the board in GDPR. That appointment can be done under the obligation of controllers and processors in GDPR, wherein in DPDP in India, only the data fiduciary has the right to appoint the DPO as a point of contact for towards the data protection board. And here in GDPR, we have something called as records of processing activity, ROPA, wherein data controller and data processor are required to maintain that particular activity, ROPA. And this India Act doesn't give any obligation for data fiduciary to maintain ROPA. Okay, and with respect to the regional languages, GDPR does not explicitly specify to provide the notice to regional languages, wherein DPDP gives 22 Indian languages in addition to English for data fiduciaries to provide the notice in those languages, wherein GDPR doesn't kind of give anything specific, or they haven't narrowed down on languages with respect to the other countries, which is part of the European Union. And a DPIA, data protection impact assessment, is to be controlled. Is to be conducted by the data controllers for all the high-risk processing activities, wherein data fiduciaries are obligated to conduct the data protection impact assessment in India, DPDP. So there is something called as data protection impact assessment, when you're conducting this assessment to ensure that how well your data is being protected. In GDPR, it is being conducted by data controller, wherein in India, data fiduciary is doing that impact assessment. These are the key differences with respect to GDPR and DPDP on scope and general information. Yes.
Just to clarify, if I understand, that means the DPDP doesn't talk whether it is applied for a natural person. That means the data is also applicable for a dead person.
So data is applicable for individual as well.
No, for a dead person, because GDPR is very clear that it is only for the natural person. That means who is
Oh,
alive.
okay. You are talking. Yes, yes. No, DPDP doesn't talk anything on that till now.
Okay. Second thing is GDPR says the rule is applicable for every citizen of EU, irrespective of where he stays, and in case if the processing happens well within the EU. Here,
Right.
we are not talking about in DPDP, we are not talking about all the Indian citizens. But however, in case if the processing happens within India, then all companies who are doing this, the rule applies for them.
Yes, you're correct, sir.
Okay.
Yeah. Your good name, please.
Cherish.
Okay. Okay. Any other questions in this key difference with respect to GDPR and DPDP?
No, thanks. I think we'll move
Okay.
to the main. Yeah.
Yeah. Okay. This information will be shared once, to all of you once our discussion has been done. Okay. So we saw the key provisions of GDPR and DPDP, the comparisons and the key provisions with respect to the data privacy. And now we'll be talking more about the stakeholders. We saw a lot of terms like data protection officer, okay, data fiduciary, okay, and agent or data processor, etc. We'll just see what generally it means. Okay, see, we have one more important term called as data principal. Data principal is an individual. It can be myself, or it can be Abhi, or it can be Abhishek, whomever it is for in this meeting. I'm just taking example names just for an example. You are the data principal, wherein any information, just give me 1 second. Yep, sorry, there was a disturbance here. Okay, see, data principal is a person who is kind of giving the personal data that is related to him. Okay, so that particular person, as I'm an individual, I'm working in an organization. That organization is asking my blood group, and they are asking my consent whether I am okay to give my blood group information to ensure that I'm a blood donor. If there is a blood donation camp happening in the organization, I can donate my blood. So I'm the data principal, and I have to give my concern, stating that yes, I'm okay with this, and for this particular reason, this organization has asked me the data from my side, and I'm okay to give this concern, and this data can be used only for this particular particular you say, like for only for collecting the blood sample or blood donation drive. So I have to give that sort of a concern, and this concern has to be taken by the data fiduciary. So data fiduciary is the person, or or a person who has been appointed by the organization to ensure that they define the purpose and means of personal data process. So if they are collecting my data fiduciary has to give the meaning of for what reason they are going to collect my data. They are going to give the purpose. And data processor can be the organization itself, or any agent of an organization, wherein they process the data, okay, on behalf of the data fiduciary. Okay, and data protection officer is an individual who has been appointed by the significant data fiduciary, wherein this data protection officer acts as a point of contact with respect to the company and the data protection board. So if any issue happens, any data breach happens in a company, this data protection officer will kind of inform that issue generally it is within 72 hours as per GDPR. In India, we haven't kind of got the timeline. So they will be the point of contact for everything. There'll be a point of contact for all the data breach and data protection, information in the organization, and they will be giving the information to the Data Protection Board of India. this data protection board is the regulatory body which is responsible for enforcing the act. So anything which is happening through this act will be controlled and enforced by the data protection board, and this data protection board will have the appellate tribunal, which is called as Telecom Dispute Settlement Tribunal. Okay, it actually handles all the appeals and complaints related to, you know, the orders or directions which is being given by the Data Protection Board of India. So when this Data Protection Board is kind of saying that, see, there is an issue and there is a settlement which has to be happen, this tribunal handles all the claims and appeals related to those orders or directions given by the Data Protection Board. So this appellate board will kind of help the Data Protection Board of India to ensure that the cases that is coming to Data Protection Board is being handled in a proper manner. Okay, and there is something called as data concern managers, wherein these concern managers are the individuals who has been authorized by the data principles. I mean, we as an individual to manage, review, and withdraw the concern through a proper platform. So these concern managers are the point of contacts for us as an individual, wherein we can say that for this reason this information has been got from me, and once the information and once the purpose is being solved, whether the data has been deleted. So those sort of information has to be processed through this concern managers. So still there are a lot of clarity which is being which has been drafted by the government to give more clarity on these terms and conditions, and who will be processing what, etc. So this slide talks about penalties for non-compliance. If an organization is not complying to the personal data protection, and if it is resulting in a failure to prevent a personal data breach, okay, the fine can go up to 250 crores, which is approximately 30 million USD. And if we are not notifying, if there is a failure to notify the breach to the board or the data principals as an individual, see, if there is a data from Madhavan, okay, and there is a data breach that has happened by the company hasn't taken enough measures to kind of protect my data, and it has been leaked outside. And if that company has not notified me or the board regarding this breach, then the fine can go up to 200 crores. Impact of the data, how it has been reached, how deep it has reached, and what is the damage that particular data has caused to the data principal. This will be analyzed in detail, and based on that the fine amount will be imposed to that particular organization. Okay, if at all, as I told you, children minor data is also very important. So if the organization is not obligating to the fulfillment of processing those children's data, the fine can go up to 200 crores. And if the if the significant data fiduciary is not fulfilling the obligations which is necessary to be done through them, the fine can go up to 150 crores.
Sorry,
And yep.
One point. Second point, failure to notify the breach to board and data principal, that by the data fiduciary, right? Second.
Yep.
Okay.
Yep. So any obligations that's been not fulfilled by the data fiduciary.
Advan, 1 second. The second point which Monty had just brought out, failure to notify the breach. Now, breach may not happen from the data fiduciary, because fiduciary is like a controller. He is just only indicating, but breach can also happen from the processor. So in GDPR, the processor also will have to comply to this requirement, and he will notify through controller. But here in India,
in India, only data fiduciary is the one.
There is no point of data processor
I've
here
given
in
that.
DPDP.
In India, it is only data fiduciary. I'll kind of show you that. See here, the data controller and data processor are required to maintain the records, and both of them has a obligation to kind of inform them to the board. Wherein in India, only the data fiduciary has the obligation to kind of inform, okay, to the board with respect to the act in India, DPDP Act in India.
Okay, then in that case, if we just go back to the same slide which you were flashing now. Okay, now the difference between point number 2 and point number 4. Now they are intertwined, because the point number 4 is non-fulfillment of obligations by a significant data fiduciary. The fine can go up to 150. That means obviously if the technical controls or perhaps the contracts don't inform clearly, the breach may happen. Now up to 150 here, whereas when the breach actually happens, up to 200 on the point number 2. So
Yes.
how does this differentiate?
No, when see this non-fulfillment of obligation is, see, this data fiduciary should have a proper mechanism, technical mechanism to ensure that the data is protected, which has been processed by them. The data fiduciary himself can be the data processor. So I'm just giving an example. In those cases, if he hasn't taken enough measures to protect the data, then the fine can go up to 150 crores. And in spite of the data breach, if they haven't kind of notified to the board, okay, if they have gone to the failure of notifying to the board, then it can go to 200 crores. It
Okay.
depends on the level of the non-compliance. Data fiduciary has many compliances to take care of. For failing to notify the breach, the not only to the board, to the data principal as well, then the fine goes to up to 200 crores. Wherein if there are other obligations that the data fiduciary has not taken care of, then the fine can go up to 150 crores. As I told, the law is kind of getting evolved and it is being kind of coming up, and still
So
lots
just
of
to
points we are not we ourselves are not clear in it. It has to come through the government only. Once the detailed information has been given, then we will come to know for which specific non-compliance how much will be the fine.
Okay.
Okay.
no, Arnav, just to also add on to what it is. See,
Yeah.
even when the GDPR initially said, okay, GDPR even now it says that it's 20 million euros or 4%, okay, of the gross global the revenue. See, this 20 million euros is an indicative figure. Okay, so 1.2 billion euros or 1.2 billion US dollars is what I think Amazon or Meta has been penalized, okay, 1 or 2 months back. That's huge. Okay, so we can anyway attribute that to the 4% of the gross revenue that they're actually making globally. But even in this particular case, see, if you look at the GDPR, it also covers the paper-based records, but that is not actually covered in the DPDP because it's a digital personal data protection. Okay, and we have started it, and as you rightly said, okay, the due care and due diligence and the gross negligence, that's something that we also discuss on the CDPO class. So depending upon where we actually missed it, okay, so the amount of penalty is definitely going to differ. Though they may say 250 crores as a limit, okay, but you cannot question the government, okay, the act itself says 250 crores, okay, but how can you charge me more, right? So they will say that the act itself says that you need to secure it, you do not secure it. So see, the act is one, but the other one is, see, there are a lot of rights that the people have, right? For example, if you look at the tort law, okay, there's no way we say that for this the injury and this what you should be as a compensation. It all subjective is what I understand, but I'm not a lawyer. Okay, I'm a simple security guy. So there are a lot of lawyers and advocates, solicitors, and everybody here, counsels. So you can let me know. So if the year of the act is going to say 250 crores, does it mean that we cannot penalize them more than 250?
No, Subra, Abhishek this side. So, it's not the maximum 250 crores. So it is cumulative. Whatever breaches have been mentioned here, it can be add on. It's not that maximum penalty is 250 crores under the act. It can be 250. If there is a personal data breach, then it is 250, right? If there is a failure to notify the breach, then 200 more, right? If there are
Oh,
fulfillment of obligations, then it can be 200 more, right? And other so on. That significant data fiduciary 150 crore. It is an add-on. It's not the maximum 250 crore. It is a cumulative, right? I hope
Yeah,
that
okay.
answers.
for each
Yeah, yeah.
occurrences, for each purpose, like for notifying failure to notify, it is up to 200 crores. Okay, if there is a voluntary undertaking by the organization, if they breach that, then it will go up to the extent possible. It depends on how much is the impact. As you said, it is more than 250 crores, not just to the max of 250 crores. For each
Okay.
breach and for
Oh,
each level of breach, the penalty differs.
okay. It's like how many IPC has been violated. So that many, that's a cumulative penalty. Like that same thing holds good here also, right?
Yes, Subbu, you're right, you're right.
Okay. Thanks, Arun. Thanks.
Yeah. So it is not an overall figure of 250 crores for the entire, non-compliance.
Okay.
Okay. Okay, how organization can be, kind of be careful and how they can ensure that they are not falling into non-compliance. So first of all, they have to familiarize themselves with the law, which is coming up in, next couple of months. They have to ensure that for what are the kind of data production that has to be taken care, and what sort of technical mechanisms that they need to kind of brought into the organization, like checking on the impact, or checking on how to protect the data, how to ensure that it is being placed in the cloud or it is placed in the data server, etc., etc., how well and how safely it has to be processed. So they have to familiarize themselves with the law and the technical assessment as well. And they have to kind of have a detailed and comprehensive data inventory process using the data discovery techniques. Okay, what is the entire data inventory looks like, or how the entire data inventory looks like. Okay, what can be done to ensure that we have a comprehensive inventory. And once we have the comprehensive data inventory, you know how to apply the data protection mechanism over them. So technically they have to be very sound in this, and they need to develop a mechanism to give the notices to data principals. Okay, how the data, personal data is being collected, okay, how it was collected earlier, and how it will be collected going forward. It has to be in a plain simple language. There shouldn't be any legal terms attached to it. It has to be in a layman language. Okay, so that information has to be given to the data principals, and that notice has to be uh, when that notice is being given to data principal, this companies has to develop a mechanism to give the notice automatically to them, to send a notice to them by defining the purpose in a plain simple language. And how to have a consent mechanism, consent management mechanism, when you collect the data, how to maintain the data, how to track it, and how to update the consent from the individuals. For example, if the consent is valid for only for 6 months, so once 6 months is over, whether any tracking mechanism is there to remind me that again the consent has to be obtained, a fresh consent has to be obtained for this particular data, something like that. So a proper consent mechanism, management mechanism, has to be implemented, built in and implemented. And there should be a proper establishment and maintenance of the technical and organization security measures. As I told you, technically the organization should be very sound to ensure that they protect the data in a much better fashion. And if there is a gap, with respect to the readiness of the act, that gap assessment or the gap analysis has to be conducted by involving the technical people from outside or inside the organization itself. Sorry. So once you conduct the gap, you will know where you are lacking, and through that, if you kind of want to build a technical system, and if you want to bring in lawyers or data protection officers to ensure that the company data is protected legally and technically, you need to kind of bring in those mechanisms in order to avoid the failure, or in order to avoid the non-compliances. So initially this will be kind of difficult for the organizations because there is huge cost involved. But once the process and the information, and once the technical tools and everything is being set, implementing them, and taking by repeated uh, implementation of those systems shouldn't be a problem for any organization. So we need to ensure that we are prepared and deploying the mechanisms to respond to data principal right request. As a data principal, okay, I might ask, okay, for what reason this being collected, whether the information is being processed, if it is being processed, whether the data is being deleted. If the data principal is asking those questions, there should be a mechanism to ensure that their questions are being answered with evidences. And all these things has to be captured in a contract, a proper contract within the data processor. Okay, and that data processor who kind of manages with data fiduciary, data principals, and data protection officer, they should have a proper legal protection through valid contracts. Okay, and whenever there is a change in laws and regulations, that has to be properly monitored, and that update has to be implemented within the organization to ensure that the organization stands up to date. They kind of ensure that they need to kind of adapt themselves to the process by keeping themselves up to date with respect to the changing laws and regulations. This is how organization can prepare themselves with respect to the new data protection bill which is being passed and which is going to get applied in a couple of months. This we have already seen in GDPR, and this one, how I can kind of make sure that I'm ready for my data privacy and data protection implementation. So in couple of months, like 1 or 2 quarters, we need to undertake a data privacy assessment to understand where we are with respect to data privacy and the requirements, and how we need to develop a framework with respect to the data privacy, okay, which can be strengthened to our organization data privacy program, and what needs to be done with respect to establishing the data privacy in an organization to drive the program. How I can kind of bring in the principles and mechanisms, policies, to ensure that I have identified the framework, and to build on to that framework what sort of mechanisms I should kind of bring in to ensure that I am up to date with respect to the data privacy assessment and data discovery classification, etc. And this data discovery classification mapping exercise to identify the personal data touch points with respect to structured and unstructured data, everything has to be kind of done through the technical people or the data protection officer. They know how the data discovery can be done, classification can be done, etc. And data inventory has to be developed, developing inventory of assets, processing the personal information, and also the suppliers, third parties, and who's delivering the services. So data is everything. How you capture the data, how you organize the data, how you protect the data is in a gist of our discussion. That's more important. In next 6 to 12 months, we can kind of update or develop the relevant policies and the procedures to outlay the intent and consistent approach towards the privacy and protection. And we need to kind of conduct the data privacy impact assessment for high risk in business functions where the high risk is applicable. There we need to kind of conduct the data privacy impact assessment, and using that assessment we'll know where are the high risk areas and how I can protect my data in those high risk areas. What is the gap which is being found in that impact assessment, and how I can fill the gaps through the technical and legal measures that can be done through these impact assessments. And beyond 1 or 2 years, like how you can take care is instead of doing this in a manual manner, you can automate them. You can build your own software, or there are a lot of softwares which might come in during that point in time to ensure that these governance activities are taken care in an automated method. And we can take external certifications through a lot of organization which gives you the certification like you're up to date, your organization is up to date with respect to data privacy implementation, and you have all the tools. So those sort of certifications will give you the confidence, and it will be used as a marketing purpose also to ensure that your organization is up to date with respect to the data privacy control and principles.
So Advan, Abhishek this side. On the lighter note,
Yep, yep.
the thing is that we all were thinking that we'll have some time around it, like 3 to 6 months and 6 to 12
Yeah.
months and 12 to 24 months. We can plan out that ways.
Yeah.
So, but Anuj, I think there is some background noise coming. So,
Yep, yep. I don't know.
okay. So, Advan, what I was saying that, like yesterday, the notification has come from the minister, right? That they are trying to get on with the rules within a month, 1 month of time frame, and they want to put it on fast track, appointing Data Protection Board of India. So, I don't really think that we'll have that much of time. Hopefully, at least a year government gives us to implement that. That's what I'm expecting.
See, definitely, what happens is once this bill is being, kind of passed as a law, and when organizations are being told to implement this, definitely this organization, from a small organization to a big organization, they will
Anuj, can
kind
you
of get
please
a,
put on a mute, please? Anuj, can you please put your system on a mute, please? Anuj.
yeah. See, once government, kind of gives the timeline, okay, I'm sure that a lot of organizations will kind of give the feedback to the government that they need some more time. Within, 3 months or 4 months, this is not possible to get implemented because not everybody will have their own data protection officer and the tools and relevant policies, procedures, etc. Definitely, it will take
Right,
6 to 12 months, as
So
you said.
when
So,
GDPR came into force, and when the standard contractual clauses mechanism was being established for cross-border data transfer mechanism, so
Yes.
there was around 2 years of time frame that was
Yes.
given by EU region, right?
Yep.
EU Commission
Yes.
specifically.
Correct.
So that's what we need to expect. I think big tech companies in India also requested government
Definitely,
for
they have see already they have requested
right.
for the timeline. Okay,
Yeah,
on
yeah.
offline it is not recorded officially,
Right.
but offline they are kind of requested through the big shots available in the industry,
Right.
and government is also trying to kind of consider the timeline. But at least to start with, they should kind of give some enforcement, right? So at least if government gives 1 year timeline, our mentality is we have 1 more year, right? So what is the hurry?
I think
So
they
only
will
when
be right. My opinion here is that what I
yeah,
have heard of in the
yeah,
market, that they will be giving timeline in a phased manner. For particular
yes,
provisions, it will be 3 months, it will be 6 months, and
exactly.
1 year for particular provisions. So that's how they will take it forward.
Exactly.
Okay, right.
Yes. Yeah. See, that's where I kind of gave the information. The act may be brought into effect in stages.
Yeah.
So when these effect is in stages, with respect to those stages, the months will be also given like 2 quarters to ensure that you have all the policies and procedures in place with respect to the data privacy, something like that. So at least in a year or two, if the stages have been fulfilled by the organization, and if government also kinds of gives the support, I think similar to GDPR in India also will be having a strong data protection system,
Sure,
and
sure.
companies also will not play around with data.
Right.
Just like that, they will be ensuring that our data, individual data, is being protected in a proper way, and there won't be any mislead or misconception with respect to the individual's data by the organization.
Right, Advan. I agree with you.
Yeah. So yeah, we are done with the discussion on the general overview and simple mechanisms being done for being implemented for the data privacy and control in India for DPDP. So any questions, we can take it now.
Advan, I'll
Yeah.
start with a question here.
Yeah.
So it just for the sake of discussion, I have confusion around it. So I just wanted to bring that up.
Yes, please.
So every organization do have their privacy policy in place.
Yes.
And under DPDP, we have a requirement of privacy notice to be given to these data principals, right?
Yes.
And
Yes.
consent obtained.
Yes.
Prior to
Consent.
that, or privacy notice has to be given prior to obtaining consent or while they are obtaining the consent simultaneously, right?
The
But
privacy notice, the privacy policy, first of all, should be there, okay?
Yeah.
And that policy should tell you the steps your organization is adopting. For example, if there is a leave mechanism policy in an organization, first of all, before implementing that mechanism, there will be a leave mechanism policy. Like this is how the employees can take the leave, etc., right? So something like that, the data privacy policy has to be there first, and that policy will give you the information or steps or procedures to how to get the concern, which form to get give to the data principals to get the concern, in which language it should be. Those sort of things has to be captured in the policy document, and only through the policy document, if it is kind of properly captured, that itself will act as a guideline. The policy document itself will act as a guideline. So policy document is the very first phase, and that policy document followed by the data privacy notice and consent notice to the individuals has to come up.
Okay, yeah, okay, that clarifies my question. Thank you so much.
Other one, Abhilash here.
Yeah.
Quick question on the data privacy. So, is there any separate, consideration on the confidentiality of the data that is being breached and the penalty that is associated with this? For example, some of the data could be utterly nonsensical. So, who does this evaluation? How does it happen?
Okay, so 1 second, I'm just kind of see the third point you're saying here, Abhi, in this slide. The act does not cover personal data processed by individuals for personal or domestic purpose or publicly available data.
Okay.
Okay, are you looking for something like this?
Yeah, something similar.
Okay, so this one, see, act kind of gives you the information on what is actually the personal data and what is the privacy it has to be applied towards the personal data. So if it is just for domestic purposes or which is publicly available, this act doesn't cover any picture towards that.
Okay, great.
Okay. You told 2 questions. You have just asked 1 question.
No, who ascertains it? I mean, I think the the decisioning on what constitutes, etc. Just wanted to understand who are the parties involved in kind of assessing.
See, that will be done by our Data Protection Board of India, regulatory body.
Okay.
Did I answer your question, Abhi?
You did. Thank you very
Yep,
much.
thanks. Any other questions, folks?
Other than Shrikant here.
Yeah, Srikanth.
So in DPDP, it is mentioned as there is no certain time frame to notify supervisor authority about the breach. So
Yeah, still now they haven't given the clarity on the timeline. As we have 72 hours for GDPR, we haven't got
yes.
the timeline with respect to the notification, breach notification.
So will it be amended later or so?
No, while it is being passed as a law, definitely they would be giving the timeline. They haven't kind
Okay.
of clearly given the timeline now. The bill hasn't given the timeline, but definitely when it is being passed, I mean, it has already been passed. When it has been kind of officially announced, the time frame will be definitely there because we can't kind of proceed further if there is a data breach, right, without a time frame.
Exactly.
Okay, so definitely there will be there still a lot of clarity has to be brought in by the government when they are kind of giving this law officially to the Indian public.
Yeah. And I have one more question.
Yes,
There is
yes,
one
please.
more guidelines of CERT India. Within 4 hours, we have to report if there is any data breach.
Jagannath, it is 6 hours. It's 6
Oh,
hours.
sorry, 6 hours. Within 6 hours, we need to report as per the
Okay,
CERT
yeah.
guidelines.
Okay, thank you for giving that info.
Okay. See, once this DPDP is effective and implemented, can European Union countries can easily make business deals with India, and their clients can easily operate remotely from India, where their European clients' data can be processed from India. How it will be? I want to know the view.
See, see here, GDPR, as you told us, GDPR has a specific mechanism for transferring the data to the other countries through the standard contractual clauses and binding corporate laws. But this DPDP hasn't kind of given anything on the transfer mechanism with respect to the personal data. But when it comes in officially, this is just the overview of what we have got through the bill. It's been presented here. Once the detailed information comes in, then we will come to know okay, how well this data protection, sorry, the data transfer can happen from the European Union to India or from India to European Union, whether any contractual clauses has to be included by the Indian company within the contract for transferring the data outside India for the services which has been rendered outside India. Okay, but the data principal is within India, something like that. So I yet to get those information. But if somebody is in this group has some better knowledge, please share it. It will be a learning for me as well.
Advan, I can
Really?
add on to it.
Yes, yes.
I'm sure you can go ahead, please. Yeah.
Yeah, so Subra, I was just trying to add on to what Advan mentioned. Like, EU citizens, Shrikant is talking about specifically. So as of now, in India, when they are transferring their data to India, there is a standard mechanism like standard contractual clauses, and there are binding corporate rules, and there are derogations. Derogations are kind of exceptions when data can be transferred. And other than that, adequacy decisions, there is a list of adequate countries that EU has come up with, and where data can be transferred without any formalities being taken care of. But looking at Digital Personal Data Protection Act of India, like government does have supervisory role as of now with respect to certain provisions, and they can take control. So India is not in that particular country list of adequate countries, right? So that option is out of context as of now. But other mechanisms that I mentioned, through that EU citizens data can be transferred to India, and it can be processed in India.
Okay, thanks.
Subbu, you're saying something towards this.
No, absolutely. See what Abhishek says. India is not
Yeah.
a part of the third country.
Yeah.
GDP is for Europe and DPDP is for India.
Yes.
So if Europeans wants to do business here, then they have to be DPDP complaint. If we want to do business, we need to be GDPR complaint. So it's the context is something which is uniquely different for both.
Okay. Thank you, Subbu. Thank you, Abhi. So any other questions?
So from this bill, so what are the cons that you identified in this bill? Adhan?
Sorry, I didn't get your question.
What are the risk or what are the risks that you identified in this bill?
See, the risk is if you're non-compliant, we'll be having, in two ways. If the consent is not being properly, obtained and the data is not properly, protected, our information will be public, our privacy information will be public. And if the organization, is continuously, kind of being failure in these mechanisms, implementing these mechanisms, and if they are being told as a non-compliant, then they have to pay hefty fine. These two are the major risks. So without proper data has to be, properly processed. For what purpose the data is being, kind of taken from you, it has to be properly processed, and it has to be properly erased after, the data has been, used. If there is a concern saying that for 6 months I'll be using your data, and after 6 months your data will be erased, it should be there should be a mechanism to ensure that data is actually erased. If it is not erased and if it is being continually used for other purposes beyond the consent that you have given, then that is a non-compliance, and your data is at the risk that it has been used without your permission, and the organization is at a risk that it has to pay hefty fine for not.
Advan,
Yeah.
I've just put the Amazon privacy notice to people. I was just trying to read through to understand what is it that we still are fearful of the personal identifiable information. Everything is available in Amazon. If you just go through, but there, I don't think beyond what is required. And this privacy notice of Amazon is last updated in 2022, August 11th. If you
Okay.
see the kind of information that has been collected by all the stakeholders and the users,
Yeah.
I think it discloses everything.
On a related note, if this DPDP comes in, is there any cap or provision on the companies to ask for only a limited amount of information to be stored, and beyond that you can't?
We are
Ideally,
expecting that.
yes. There is
Yes.
something called a data minimization that is
Yes.
important.
It is there, Abhi.
Okay, okay. Yeah.
But the level of the information which has to be collected, we are yet to get that fine details.
Okay, okay.
So, is there any definition of sensitive personal data under this bill?
Sensitive personal data, no, I haven't gone through that. I haven't got that sort of information.
No,
No, there is
Advan,
there
it
is
is
only
not.
one category. There is only one category.
Yeah, Abhi, you are saying something, Abhishek.
Yeah, I was
Please.
just mentioning to what you said, Advan. There
Yeah.
is no specific,
Yeah, there's no specific definition towards that.
with respect to
Yeah.
sensitive personal data. Every, piece of data is covered. Personal data is covered under it, digitized.
Okay.
So see, in coming months, in next quarter or next 2 quarters, we'll get more clarity on this DPDP bill. Okay, and once it gets implemented on stage by stage, based on the feedback from the organization and based on the experts in the field, this will change. It started now. It will have a continuous evolvement. After a couple of years, like GDPR is in a constant and in a much rigid stage. This bill also by I believe by 2025 or something 26 we will have a better bill. I mean better law in India with respect to data privacy. It will take at least couple of years to ensure that everybody understands it, and there will be a lot of revisions towards it. And based on the feedback, government also will kind of make loads and loads of changes towards it. And if organization is saying that fine is too much, there will be some backdoor to ensure that this backdoor discussion to ensure that fine amount is also getting reduced. So we are kind of looking forward for much more directions from the government with respect to this particular act. So we need to wait and watch.
So, Advan, one thing I just wanted to check with you, or maybe if, you can help me out.
Yes,
I was
please.
also, I mean, listening to the way you are into, this legal line. I was talking to, I mean, I was listening to, some webinars, and there was question also. So the RTI Act is gone, almost it is gone. Like personal information, I can't claim and ask for your personal information. Point number one. Point number two is, 43 Act is also almost gone. I mean, in nutshell, since physical and digital world is almost getting merged, okay, because
Yeah.
the way digitization is going on. So
Yeah.
some of the lawyers or seniors said that going forward there will be a umbrella like structure and DPDP Act, and Sue has talked some time back, Disha Act, that is almost equal to HIPAA of US. So I mean, is there anything of that kind? There'll be that from digital point of view, there will be a main law like, and the IT Act or DPDP etc. will be part of it. So any idea you have? I mean, have you heard anything of that kind, that this will be the way forward?
No, I haven't heard, about that, what you're asking, I can understand. But see, as I told you, it started with our IT Act in 2004, 2006, etc. And slowly there are loads and loads of rules that's been built in, loads of act which has been built in, loads of updates happen, amendments happen. And now we are into this privacy. In
Okay.
future, we never know. It both might kind of, merged as a single law. We don't know. As you said, as an umbrella, everything can be brought into a single law stating that IT and Privacy Act.
Okay. Okay.
We don't know. It depends on how well the organizations are ready to adapt first this this DPDP, because IT Act itself, not many people are aware of. Those
True.
who are in the IT field and those who are really in a much bigger companies and lawyers, they are aware of it. Then they are kind of they're okay to obligate to the terms and conditions. Okay, but this one DPDP is much more rigid, and it applies to all the organizations who is processing the data,
Yes.
who is kind of collecting the data. So first, the organization has to be ready for this, and they have to implement this, and they should ensure that they are following this process. But see, our Indian mentality is, if somebody is saying that no, I have to pay fine, you have to pay fine if you're not doing this, first they'll say, we'll take care, no worries, we'll see. That's
Okay.
the general mentality we have. I'm not talking about the
Hmm.
big organization, the medium and small organizations in general. Okay,
Okay.
so first we have to come out of that mentality, and once we are so responsible towards the law, I'm pretty sure that we'll be kind of following the IT Act also in future if we are following this DPDP in a proper way, and everything can be managed for the ease of operations by the government in another 5 or 10 years timeline. But definitely it will take some time, and we should be the first root cause for that sort of change. We should be obligating to all the rules and regulations. And once it is done, I'm sure that we'll have this, umbrella structure going forward.
Okay. So one more thing, this company act, I mean, in the same, some of the webinars, people said they are not sure or nothing has come out, but some of the legal advisors said that even the company act may get modified because the way
Yes.
digitization is going forward,
Yeah, it is.
even
It is. It is kind of the discussion is going on,
Acha,
but
acha.
we never know what is the surprise that it might bring you in a day or two. Tomorrow is also, we don't know. All of a sudden, India name is changing into Bharat. You heard it during this G20 summit. Before
Okay.
that, at least 50% of the Indian population doesn't know that there is something like this existing in the constitution. Also, the support is there. So, and I'm not politically, debating. I'm just giving you an example. So you never
Hmm.
know what the government decides, what the government thinks for the next 1 week, and all of a sudden it might, kind of give you the surprises. So lawyers are also expecting there will be a lot of changes. We heard about it regarding the
Acha,
Company
acha.
Act 2030, and we hear that there might be changes in IPC and CPC also. There will be
IT,
first of all, there might be the name change to these acts in Sanskrit. We really don't know.
which one? Which one? Please come again.
For IPC and CPC acts and all, there might be a
Acha.
name change
Okay.
in our local Sanskrit way, like what
Okay.
India has changed into Bharat. Soon there might be
Okay.
a name change also for these acts
Okay. So you are saying a lot of discussion is going on, but
going on in the
publicly not
background. Yes,
known. Publicly
exactly. We
not
don't
known.
know
Okay.
until it comes from official announcement comes from the government. We don't know.
Okay.
No,
Okay.
no,
Okay.
Adhavan, you are actually right. Manoj, okay, just to also add up to what we are discussing here.
Yes.
I was because for good or bad, I know a lot of police officers and I used to interact with them. And last week when we had a chat with one of the investigating officer, he was assistant
Uh-huh.
commissioner of police, and he was
Mhm.
actually telling me that the law that we have it now, the Indian penal
Mhm.
codes and criminal law and civil law and all, no? It was
Mhm.
something which coded or codified in 1947.
Yes.
Okay, now we have gone through a lot of loopholes, a lot of cases, people escaped left, right, and center. So it's
Mhm.
being amended now. Okay, and this also something which I heard from the law students who were from the Savita Law College in Chennai. So when I
Okay.
went to deliver the seminar on the the social engineering attacks and all, they were actually telling me it's actually getting amended. It's getting much more stricter. So ideally, that will get inherited by this DPDP also. Okay, so that, and they would say that see, I'll tell you something. If government is going to decide that, okay, we are going to withdraw all the currencies, it's going to be only digital rupee, okay, entire the scenario is going to be different. There cannot be a backdoor way of, because it's anyway funded. Every rupee is counted. There cannot be a backdoor way. You have to pay them, what the penalty is. Okay, nobody escapes. It'd be like that. Okay. Let's see, because if that type of a control that we are going to introduce, then people anyway, people are leaving the country, settling down somewhere they are saying, right? If every country is going to introduce the same way, it's going to happen. Maybe it'll take 10 or 20 years. But what I'm saying, it's getting modified. The criminal law and civil law is getting modified. Maybe by this year or next year, we'll also get to know that.
So you mean to say this, even these laws that has been existing for ages are getting modified, is it? Okay.
Yeah. See, 70 years back, the road was something different and the petrol was only less than 10 rupee. But now it's more than 100 rupee. What I paid there, what I'm going to pay now will be different. Entire third landscape is different, population is different, everything is different. Law cannot be same.
Yes. Point. You have a point. Yeah. Thanks.
Yeah.
Thanks, Arun. Thanks, Subbu.
Thanks, Manoj. Thanks. Any other questions, people? Okay.
Hi, this is Rajesh here.
Yes.
Other one, do you have any other things we need to discuss regarding this DPDP Act of India?
No, for time being, no. Once the changes comes in, definitely I'll come back.
Participants, do you have any queries in this, or if you have any clarifications, please come out and we have to discuss with the other one. Unless we just go for a end. And Adam, can you please stop sharing your
Definitely.
We just want to take one small people who will be joining here. We have most of the participants here. I just request with the participants, can you please on your videos in a minute? We just want me to know about who will be joining in our webinars to get more clarifications. And this is a healthy conversation is going ahead. We had and we hear a lot of information to be shared, and the people who will be interested in the DPDP Act. And thanks for everyone who will be joining in that forum, and we will had a good time in that. We have a lot of informations we just discussed here, and thanks for your participating in this forum. We are just want me to be closing this one because our meeting is just scheduled for only 1.5 hours. So we just want me to planning to close it. In case of any clarifications or any queries, you please contact my mail ID I provided in the mail, in the invitations which I sent it across to you people. Subbu, do you have any word with your people? Can you please? If you don't have any information, then we just want me to close this forum. Thanks for joining these participants.
Thanks.
Thank you very much.
Thank you, everyone.
Thanks, Subbu, for inviting us for the seminar. Thank you.
Thanks, Subbu, for a very informative session. Thank you.
Thank you, sir.
Thank you.
Thanks for conducting this.
Thank you very much.
Thank you.
Thank you, everyone, for an insightful session.
Thanks.
Thank you.